Hi, my name is Justin Levitt. What you're about to see is a simulation of an interview at the AALS interview market in October in Washington, D.C. We are attempting to portray a realistic 20 to 30 minute interview of a hiring candidate. You'll see some questions that you might expect, or similar questions that you might expect of anybody on the entry-level market. We have a very experienced, exceedingly distinguished, tenured professor serving as the interviewee, so her answers will necessarily be a little more polished than many entry-level candidates, but hopefully give you a good idea of what you might expect. I want to thank colleagues from USC and from Southwestern Law School and from Loyola Law School. I particularly want to thank Professor Priscilla Ocen, who has agreed to serve as the interviewee for this video. I hope that it is useful for you. I hope it serves to demystify the process a bit, and I wish you the best of luck. So thank you very much for coming, Priscilla. It's a delight to meet you. My name is Justin Levitt. I'm here with colleagues.
I'm Cindy Archer. So nice to meet you, Priscilla.
Very nice to meet you. Thank you for having me.
I'm Franita Tolson. It's a pleasure.
I'm Daria Roithmayr. It's great to meet you.
Good to meet you.
I'm Mike Dorff. Pleasure to meet you.
Good to meet you as well. Thank you all so much for having me and for the invitation to be here. It's a real honor.
Of course. And we know you've got a busy schedule. We thank you for being here with us for now. Let's get right into it, because I know we don't have much time with you. You've prepared what I think is really a marvelous paper here. It's exceedingly well written. And by that I mean it's just a delight to read. It's really informative. But rather than try and summarize it, I'd much rather hear you talk about your work. So how would you present this? What's the paper that you're giving us today?
So the paper. So in the paper, I try to bridge two literatures. So on the one hand, you have a rich literature about assaults on women's reproductive rights, reproductive liberties, reproductive autonomy from a variety of different sectors: state legislatures, hospitals, welfare offices. But that literature seldom references prisons and policing. On the other hand, you have a literature, a robust literature about incarceration and its racialized effects and the way in which it's devastated Black and brown and poor communities, increasing the incarceration rates in this country to a scope that is historically unprecedented in the world. But that literature doesn't mention women very often. And so in this paper, I try to bring those together. And I argue that women's prisons are an institution that regulate and suppress women's reproductive autonomy, their ability to parent and procreate. And I argue that that's perpetuated by the operation of federal courts and their deferential approach to fundamental rights and fundamental liberties, like the right to procreate and the right to parent. And because of those failures, I argue that we need a more capacious intervention into women's prisons. And I call for a reproductive rights and a reproductive justice, in fact, a reproductive justice intervention into women's prisons to provide the kind of support that women need to allow them to make choices about their bodies and to have quality relationships with their children.
And I notice you spent sort of a large portion on description, you spent a smaller portion on doctrine and doctrinal analysis, and then it seems like you thought it was important to go beyond the doctrine, beyond the strictly legal. Tell me a little bit about why.
Well, I did so why I felt it was important to go beyond the strictly legal is because time and time again, which I tried to describe, which I described in the paper, the federal courts have simply failed to protect women and other people who are incarcerated in women's institutions, mostly because of a decision that the court handed down called Turner versus Safley, which essentially inverted the fundamental rights framework, which traditionally applies strict scrutiny to fundamental rights related to procreation, parenting, and reproduction. And as a result, there's been a proliferation of policies that disproportionately affect women, their children, and their ability to have relationships, and women's abilities to make critical choices about their reproductive capacities. And not only have we seen that with regard to the Supreme Court in In prisons, we've seen it more generally with regard to the negative rights framework, which is to say government should simply stay out of the choices that women make. But when you think about women's prisons, it's not about their ability to make choices. They need to have resources in order to make choices about what to do with their bodies and how and whether they're going to parent. And so in order to do that, we need to go beyond the traditional negative fundamental rights framework, which is available in other discourses like reproductive justice.
So I had a question about the second part of the paper in which you talk about the modern prison configuration as incapacitating mothers, as distinct from the historical work that you do in the first part.
Mm-hmm.
And I'm certainly persuaded that regulatory control was very much at the heart of those early historical choices. But I'm less convinced that regulatory control, as opposed to either the persistent effects of historical choices or failure to accommodate difference, is still at the heart of the incapacitation that you describe. When I think of regulatory control in the mode that you're talking historically, I'm reminded of Loïc Vacan's work on the way in which incarceration serves economic purposes with regard to dealing with people who the economy has rendered as have-nots. And so I'm looking for the kind of functional payoff for the regulatory control of the modern system as opposed to the historical description. And so I just want to invite you to say a little bit more about regulatory control and the functions that incapacitation is serving in the modern era.
I think my argument doesn't turn necessarily on the intent to regulate women's reproductive capacities and their ability to mother their children. Although I think in some cases that is in fact the driving force behind policy. So for example, I discuss a set of a policy of, or not necessarily a policy, but a practice of sterilizing women in California prisons, right? Where in that case, the person who was performing those sterilizations explicitly argued that he was doing so because he wanted to save taxpayers money. He explicitly said that these sterilizations, which were done under coercive environments or without informed consent, that he performed those sterilizations because he believed that they would save taxpayers money because these women wouldn't have children that would then be on welfare, right? So in that case, that's clearly an example of an express purpose to regulate the ability of women to have children, which this particular prison official believed to be propagators essentially of criminality and depravity and burdens on society. You also have sort of the way in which women enter into prison. So women are criminalized often for choices they make related to their identities as mothers. So decisions that they make while they're pregnant, or a decision to send a child to school outside of an attendance zone, or to send a child to a park while they're playing, right? These are all ways in which women's identities as mothers are directly regulated by the criminal legal system. But then there are sort of indirect effects that are, I think, vestiges of these earlier eras when women were directly regulated, part of the earlier reform era when it was directly about rehabilitating fallen women and fallen mothers. As I sort of trace in the paper, while the explicit mission of reforming women has fallen to the wayside, prisons continue to function in that way, even if it's not directly articulated. So for example, visitation policies that restrict the ability of women to have relationships with their children, citing prisons hours away from urban centers where women would have an opportunity to have relationships with their children, lack of medical care for pregnant women, shackling during labor. These are all policies that function, whether they're intended to or not, to undermine the right to parent and the right to procreate for women. So at the end of the day, my argument doesn't turn on whether, in fact, women's prisons are intending to incapacitate women's identities as mothers. They, in their functions, they are. And I think we understand that in the context of racialized mass incarceration, right? We understand that at the outset of imprisonment and the institution of the prison, they were deeply racist, right? They were intended to re-enslave populations in the South and to create an exploitable labor population. Today, that's not the way prisons function. Most of the time, people are idle. But they continue to have a racial regulatory effect, even if the explicit racial foundation has been disavowed. I think it's the same function in the context of women's prisons.
Just to shift gears a little bit, I want to invite you to talk a little bit about one of your works in progress, the At Home and Under Siege paper. It looks really interesting. I'm just wondering if it connects with this current project at all.
Yeah, it does. So part of the work that I do is to look at the way that the ideological constructs of Black women make them vulnerable to policing and surveillance, and make them also vulnerable to being underprotected by systems that are ostensibly designed to protect them. So in that paper, which I'm going to be co-authoring with Devin Carbato, we argue that the house, the home, which is supposed to be the most vaunted, the most protected space in criminal law, right? There are several doctrines that give individuals the power to use extraordinary violence. For example, to use deadly force to protect the home. There are also doctrines in criminal procedure that require law enforcement to have warrants, for example, to enter the home. There are extraordinary procedures that the state must undertake in order to violate the sanctity of the home, right? The idea that a man's house or a woman's house is their castle simply don't apply when it comes to Black women. So in the paper, we highlight a series of doctrines that are essentially new administrative procedures that undermine the ability of Black women to enjoy the home as a safe space. So we talk about, for example, home searches in the welfare context as mechanisms that the state utilizes to circumvent the warrant requirement for women. We also talk for disproportionately Black women who rely on state support. We also talk about, in the context of criminal law, the way in which Black women are not safe in their own homes, particularly when they invite the police into their home when they're calling for help when they're suffering from mental illnesses or domestic violence, when they're disproportionately victims of police violence in their homes. So that's why the paper is called At Home and Under Siege, the way that Black women are disproportionately victims of violence, of state violence in their own homes, based on the abrogation of these various doctrines that are supposed to characterize the home as a space of extraordinary protection, but for Black women, it's a space of extraordinary vulnerability.
The title made me think of the woman from Florida who, I think her name is Marissa Alexander.
Right.
Yeah,
Right.
It made me think of her situation and how she ended up in jail, basically trying to defend herself in her home from domestic violence.
Precisely,
Yeah.
precisely. And those are the kinds of cases that we hope to talk about. And we hope to describe a set of new administrative procedures that is again, while this is applying to Black women, we think that it's creating a whole new, essentially criminal law doctrine that is existing outside of what we consider to be the canon of criminal procedure.
So I wonder if we could switch over to the teaching side, and maybe we'd start by asking what your ideal teaching package would be.
Yeah, so my ideal teaching package would be criminal law, family law, and race, gender, and the law. I think given my scholarly interests, I would be able to delve into each of those courses in a way that's deeply meaningful to me and the students. And in talking about the paper that I presented today, each of them have an element from each of those doctrinal areas. So criminal law, for example, obviously from the paper to writing about prisons and policing. Family law is an area that I'm deeply interested in, giving the regulatory effect that it has on vulnerable women, and obviously race, gender, and in the law is an area that I've been focused on in my career, in my practice, and one that will continue to be a part of my research agenda.
Now, at this stage of your career, you're coming out of a fellowship at UCLA, and you've been doing some teaching there. Is that right?
Yes.
Maybe you could talk a little bit about what kind of teaching you've been doing and how you approach teaching, what methodologies you use in the classroom. That would be really helpful.
Yeah, so at UCLA, I taught critical race theory and a seminar on race, gender, and mass incarceration. The seminar on race, gender, and mass incarceration was one that I created. Was one that I designed based on the emerging literature that's not as large as I would like, but one that is sort of out of necessity interdisciplinary, because there's not as much writing as there I think should be on women in the criminal justice system in law. And so I was drawing from sociology, criminology, gender studies, and a number of other disciplines to constitute that syllabus. It was highly participatory, obviously, as a seminar. The students often led discussions, and they wrote papers at the end of the seminar and made presentations at the end. One of the things that I prided myself on as part of that was really looking to the students as intellectual equals, and I think that they took up that mantle in terms of how we facilitated the classroom discussions. I had a number of experts in the field come in to facilitate discussions and present their work. The students were able to provide feedback to the scholars who were presenting their work, and also learn sort of what was on the cutting edge of scholarship. In addition, as part of that class, I presented a series of workshops that, for example, scholars like Dorothy Roberts presented papers. So, for example, she presented a paper on the relationship between the welfare between foster care and women's imprisonment, and that was something that students were able to participate in. So it was multifaceted, multidisciplinary, and students were deeply invested in shaping and directing the course of that seminar, which I think really enriched their experience. With regard to critical race theory, that was not a seminar, it was a lecture course.
It was lecture, okay, good. How many students were in that class?
There were about 25 students in that course. And I essentially used many of the sort of canonical articles from critical race theory. We looked at different sorts of methodologies, some of the debates and controversies involved in critical race theory. We looked at the history and evolution of critical race theory, and I tested students at the end using a standard exam at the end of that course. In terms of my my sort of pedagogical approach in that class, I used a lot of multimedia. I invited students to participate on a voluntary basis because I wanted it to be a very open environment. Students felt, from the feedback that I got at the end of the semester, students felt like it was a safe space for them to contribute their ideas. I used a lot of PowerPoints so that I could try to both reach students that were auditory learners, but also students that were visual learners, as well as a lot of activities to try to demonstrate many of the complex theoretical materials that I was utilizing in the course. So those are some of the ways in which I tried to use multi different types of modalities in class to express various kinds of concepts and ideas that were inherent in critical race theory.
Well,
Please.
What kind of exam question did you ask at the end of the critical race theory class?
Oh, what did I ask at the end of that class?
Were they like hypotheticals?
It was a hypothetical.
Yeah. Okay.
It was a hypothetical. I think it had something to do with an affirmative action policy at a university. And I can't remember precisely.
Yep.
Yeah.
when you move from a seminar to a larger classroom, like criminal law class would be, one of the major challenges is that, especially if you're relying on volunteers, the volunteers get it, right? And you have a sense of, or at least you have a sense of whether they get it. But there are a lot of lurkers in the classroom. There are students who are there, and maybe they're paying attention, maybe they're not paying attention. Have you thought about how to meet that challenge in a large classroom of figuring out which students are really with you and which students need more help?
Yeah, so what I've had a chance to talk with a lot of colleagues, you know, being at, during my fellowship, I've tried to take advantage of the fact that there are a lot of classes in a lot of different areas, and being able to sit in, for example, on a criminal law class and talk to my colleagues who teach in that area, and to see the different styles that some of my colleagues use. So some use cold calling, some use panels, others use volunteer, others give credit for participation, which I think does encourage students to step forward. I think in terms of my style, I would probably use something like a panel style, and move through the class and try to keep track of who is participating. I would try to encourage students to speak once or twice throughout the course of the semester, while creating a safe space for students to contribute their ideas and to respond to questions without feeling like if they don't exactly hit the mark, they'll be shot down or made to feel embarrassed. So I think as an instructor, it's my job to try to encourage innovation, to encourage students to take risks, and encourage them to volunteer, even if they're not on a particular panel for any given day. The other thing that I've seen work very well, both in my seminar and also in critical race theory, is putting students in groups. And asking them to do projects together. So one of the things that I plan to do, for example, in criminal law, is to ask the students to do a live client simulation, where I would assign them, I would give them a client along with an indictment, a memo from a public defender, and ask them to come up with a theory to defend the client. I'd put them in groups, ask them to interview the client, and then to submit a memorandum on behalf of the group. And I would do, obviously that's a more involved project, but I think I would do some smaller things like that throughout the course of the semester, so that all of the students would have an opportunity to participate in meaningful ways, and ways that I could give them feedback as well.
Terrific.
Transition one more time. I love what you've written and really look forward to reading more, but thinking about our particular institution and where we're situated, a lot of your background is in California and some in New York and some major cities where there's opportunity to do a lot of this study. We're a little bit smaller, locale, college town, Midwest. Tell me about your transition to a university in this setting, what you look forward to, what some of the challenges you might see that we could either help you address, and how, if at all, that may impact your ability to continue to do some of the work that you're doing.
You know, it's interesting. It's actually, I'm interested in your school because you're not in California, right? I spent most of my career, I spent most of my life here. I grew up in California, mostly in big cities, and I'd welcome the opportunity to live in a different environment, and to see different parts of the country, and to live in different parts of the country, frankly, where a lot of those parts of the country where they're a lot more affordable and a lot less traffic. The only concern I would have is just sort of, you know, where can I get my hair done, you know, so long as there's some good recommendations, I think I'd be fine with that, you know, but otherwise there are planes, there are conferences, there's Skyping, and I can keep in touch with my family and friends that way, but I'm more concerned with fit, and I'm more concerned with the opportunity to do good work with wonderful colleagues.
Do you have, I know we're short on time, do you have any questions for us?
Do you have a place where I can get my hair braided? Do you?
I think I can help you out with
Okay,
that one.
all right, okay, I think that's fine. So I guess my questions are about your doctrinal needs. So what are you all looking for in terms of your needs around hiring? I guess, yeah.
Yeah, so I think it's fair to say we are looking for exceptional scholars who are versatile, and we look for them across the board. We have particular needs coming up this coming year in family law, which you mentioned was a preference of yours. But this will not be a surprise. We're always looking for people who are adept and able to step into teaching larger first-year courses, and so we'd be very much interested in your coming out of the crim rotation. Again, mentioned an interest of yours. Beyond that, we're really looking for productive scholars who enjoy teaching and really want to be part of the community. And I think we have a pretty broad field of folks that we're talking to. We're certainly delighted to have you in that mix. It's really wonderful to get to meet you and to learn more about the work that you hope to be doing.
Yeah, and how do you support and mentor junior scholars?
So I can speak a little bit to that and then leave to one of my colleagues. We try whenever possible to ensure that junior scholars are mentored. We do that by a little bit easing off some of the first very early teaching loads. So we try and leave you space to develop your scholarly agenda. We have monetary research grants that we offer in order to further research agenda. And we have both formal and informal mentorship pairings where we try to make sure that everybody who comes on board is paired with one or more individuals who can help them, both inside their area of expertise and beyond. Sometimes it's helpful just to have the ability to toss around thoughts with somebody who's not necessarily exactly in the same doctrinal line of work or with the same research agenda. But those also, we find, grow organically in addition to the ones that we set up at the school. We hope that people will feel free enough to wander around the faculty and find other mentors of their own choosing, of their own selection. We think it's a pretty collegial environment, and so we like to think that people find their home, even aside from the nice little protected areas we set up, that people find their home more generally.
Okay.
I know you've got lots to get to today, and I don't want to have you late for your next appointment.
Okay.
So we really all appreciate your time.
Thank you.
Such a pleasure to meet
Thank
you.
you.
So.
Thank you.